how law is a production of certain groups. So the entry point to me of the legal narratives in the field of research is really this idea of matrice narrative, or this idea almost a bit of ideological of an intellectual history of a general narrative that could be constitutional Europe, internal market, social Europe, Europe of values, that ends up also shaping the construction of the practice, and it offers a cognitive tool. So this is, the legal narrative is a way to think about cognitive tools to decipher a complex polity like the EU, and also economists have done that with various different theories of economic integrations to try to decipher what the various stages of integrations were. So we are on the right track, and narratives also come with conceptions of legitimacy to it. They are parts of the imaginaries of the judges, but not only the judges. As we heard before, there's also lawyers, scholars in the field, national judges, and so then all these narratives are, to me, located in specific groups. There are groups that sociologists and Antoine Vauchet have analyzed as groups that meet, groups of scholars, lawyers, judges. Through the FIDE, there was really a construction of this group of lawyers, and these groups are more or less relevant in networks at certain times or other times, and at times also when there's certain history and moments of EU integration. If you study the Euro lawyers, the Vauchet and Tommaso Pavone, he wrote a brilliant article from Marx to Markets that really shows how the Euro lawyers were somehow the entrepreneurs du droit, and how they mobilize EU law to do particular things, with specific narratives in mind of EU law. You see how this sociological approach is very relevant for our work here today. So narratives are glues that glue together legal actors, and often they emerge as counter-mobilization. Counter-mobilization because the big narrative that, for instance, Jan Kumarek is exploring is the constitutional one. But if you think about the work of historians, Morten Rasmussen and my colleague Bill Davis, what they've done is really to show that this constitutional narrative of Europe comes very late in the 90s, and behind it you had Eric Stein and then later Joseph Weiler, who were really promoting this idea of constitutionalization when other legal narratives of supranationalism and federalism were in decline. So they were responding to the dying alternative narratives of Europe, and they were promoting the constitutional narrative. How do we measure whether these why did Antoine pick certain narratives and not others? We have to measure whether this narrative is robust, and whether it has a stable meaning, it's coherent, autonomous model, and it's grounded on the jurisprudence on the court, especially through on the one hand, it's an autonomous concept that reappears not only in the jurisprudence of the court and then is legitimized by the doctrine, but it's also not too stretched by its audience. So the audience tries to politicize the concept and stretch it with strategic goals, and the question of how much the court can maintain that autonomy of the concept. And to me, there's another part that is very relevant, that it allows you to move from the matrice to the fragment. Is really the genealogy of the legal narrative and how it evolves, not only in terms of intellectual history, but also I reflect specific economic and historical circumstances. Think about when you I did some work with Mark Bevier at Berkeley, and we did this genealogical work, and what we did was really like think about the text, and you start seeing the track changes. And you see how the changes sometimes are inspired by real concerns, sometimes are accidental. They show dilemmas, traditions, contingencies, situated agency, and also elite narratives and resistance to it. And so genealogies allows us to move from, at least for me, me from the macro to the micro. And the micro is really relevant to me because you can do lots of empirical work. If you start looking on the micro level, the cases, the specific work, we can turn to empirics. And I have to say the work of iCourt, I was just there for a big keynote of Joseph Weiler, and the work of iCourts, it's refreshing because in a way they always start from this empirical turn, which is also a problematic turn in the US because now you cannot do law if you're not an empiricist. So in a way I am aligning myself to mainstream legal narrative, but of scholarly prestige, but I do think there's something to start from the empiric and the micro level without being trapped in the micro trap. So the idea would be that if you start from the micro level, you take the fragmented approach to legal narratives. You start thinking of knowledge, reconstructing the knowledge at the micro level as a question of meaning, as opposed to a question for reflection a la Rorty. You think about quest for meaning in terms of creating meaning. The various actors coming together, they create new meaning. And Brunner and Amsterdam wrote in 2000 this amazing book called Mind in the Law, where they really look at the Supreme Court case by case, and they do this approach to how is meaning of the law a co-creation of human actions, history, culture, and language. And they start really from the facts, judicial facts. Why judicial facts are so relevant? They do come from the local context. The facts at the Court of Justice, they come from a local context. They acquire meaning through norms that qualify the events in legal terms. You can only bring a case to the court if it's something that is part of European law. The conflict is translated into a European context. The actors in the play and in the procedure have a particular role. They also have a role in their own communities that they play, and they play a cultural and political role in the community they belong to. Narrating these stories at the micro level recreates a puzzle where law is simplifies legal realities, and narration explores the possibilities of making space for human events, context, and multiple dimensions. The facts are often an artificial nature of a narration. Jerome Frank, an American legal realist, talked about this already in the 30s. They're very contested. Most of the time, courts show only facts that are the ones that are narrated by the parties, and then you need the empirical sciences, the Brandeis brief, to bring up other facts or other social evidence. How do we move from everyday facts to legal facts, right? There is a transformation that the court does in telling us this story. And there's at least 3 steps. One, the courts, these legal facts are reconstructed from the context. So we have some context of the national court doing the preliminary reference. We have the brief of the National Court. Today, the Court of Justice has opened its archive in Fiesole, and if you're interested in looking at the dossier de procédure of the cases, of course we have a 30 years delay rule, but it's a very fascinating enterprise just to open the dossier of the court and then see how you do get the judge, the decision of the tribunal where the case comes from, the question of the preliminary question from the national judge. Then you'll see the whole procedure in front of you. If you decide to open this dossier, they can be sent electronically everywhere, and they're in the language, of course, of the parties. And the court we're fighting over that is not making the official translation, the unofficial translation, which is French, but available to the public. So that's a fight worth fighting. So we reconstruct the facts in context. They include the voices that are silenced or marginalized or not really picked up in the narrative of the court. And then we can understand how the legal meanings are modeled. In 3 ways, at least. We connect the nexuses of the causes and the time between the events. We understand which characters play key roles in front of the court, and also what are the roles roles and actions that are attributed to them in the story of the Court of Justice, right? So that when this connects us to the bigger matrice, in the sense that when the court picks, as I was trying to say before, among the fragments, the ones that are more relevant for its big legal narratives, the court makes that choice, whether collectively, we don't know how it makes that choice, but we can see how the various fragments become a unified narrative. And finally, this allows us to explore the resistances, the counter-narrative, the oppositions to a unified mainstreaming narrative, and also the events or the arguments that have been cut off from the official stories. Riesman wrote about this in 2007. The narrative approach prompts the researchers to go beyond the surface of things. Jan Gaker, in The Perplexity of the Judge Who becomes the Scholar Opportunity, she wrote this beautiful piece on the German Law Journal in 2017, using Paul Ricoeur to show that our narrating is already to explain, and so how narrative is essential for practitioners, the one who will bring the case to the court. And the story of the narrative does determine the outcome of the case. So what I did in my piece that I didn't even start talking about, I tried to break down this micro-narrative or the fragment and link it to the broader narratives that we were presented with, the matrice. The idea is that in European law, a narrative approach, and if you open the dossier de procédure, what I did open 3 dossiers de procédure, the Costa one, the Van Duyn, and the Fresne. And why did I do that? Not only they were the language access for me was French and Italian. So it was really hard to read Van Gendelus without the French translation that the court doesn't want to give us. So I used these three dossiers, and what I did is I went into each dossier and I tried to at least look at 3 different things. Facts, how the facts had been retold by the Advocate Generals or the court, and how other actors had put their emphasis on other facts. Other actors in the Costa case, what becomes really clear is that while the Advocate General and the court really put emphasis on the issue of primacy of EU law, it becomes clear that the architect of this case is a lawyer from Milan, Gian Galeazzo Ciani, and there's a beautiful story of how Gian Galeazzo Ciani was close to Firmino Costa. He was very close to the aristocratic circles in Milan, super conservative, very unhappy about the electric nationalization of the Italian Enel, and what he did, he and I can say, I don't know if I have time. How much time do we have left? Okay, so what he does, he uses the facts, Gian Galeazzo Stendardi, really to say that what the Italian nationalization is doing, the underlying goal of the law was to destroy the free market economy, apply a Marxist and Leninist principle in sharp contrast with the goals of the internal market. He talked about the need of liberalizing the Italian economy as a power call for the ECJ, relying on the local bar to make sure not to push for unnecessary liberalization unless its judgments are more likely to be solicited at the right time and to be perceived as responsive to community ends. So Stendardi is really putting this kind of narrative out there of Europe for the free market and liberalization, and the court has a counter-narrative on the table, which is the counter-narrative of the lawyer, of the Italian lawyer of the Enel, also Professor Massimo Saverio Giannini, who is talking about, look, if you want to have a competitive political economy of energy in Italy, you need to nationalize as unified and lower prices for consumers and allow the energy to also reach the countryside and also become a competitive energy market in Europe. So this narrative doesn't really make it. Gian Galeazzo-Ciani represents the facts of these communists are taking over Italy with nationalization, and is very successful into representing the facts of Costa Enel, which are not really what we focus on as lawyers. We always focus on the primacy of EU law and the fight between, refer in this case to the Italian Constitutional Court or the ECJ. The other case that I use to show the style or the form of the law and what are kind of the stylistic tool that the courts use, and I really use the work of Justice Sinisha Rodin, who's been writing a lot about the ontologies of the droit, or he wrote a lot about the économie générale as a stylistic or formal tool that the court uses to do politics, basically. But here I use the Fresne, and what I see is really that while Advocate General Trabucchi is very much, is the architect of direct effect, in this case is an Advocate General. Prior he was one of the judges behind Van Gendelus, and what he says is like, look, direct effect and the fact that Mrs. Defresne was did not get her full pension benefits should just be is just a violation of EU law and indirect effect, because this should be basically a direct consequences of the article of the Treaty of Equal Pay of Work for Men and Women. What turns out, though, is that in that case, the court does follow this principle of direct effect. So formally, the style and the form is impeccable, but there's other arguments on the table, and those are the arguments of the Irish and the UK governments. They say, basically, if you implement this notion of direct effect from when Mademoiselle Defresne wants it to be, so she gets back her pension benefits since the mid-60s, as she wanted. What happens is that we're going to go bankrupt. I mean, the UK only acceded in 73, but basically the date of the judgment was 76. If the direct effect was applying retroactively, it would have gone back to 62. That's what the lawyers of the party were seeking for. In fact, Ellen Vogelpolsky was very disappointed by the fact that at the end the court decides the non-retroactivity of direct effect in the Defresne case. So Mademoiselle Defresne doesn't really get, in the end, her pension benefits. So the party is not really happy with the outcomes, and we see that the arguments of the cost of Europe, which were the arguments of the Irish and the UK governments, is an argument on the table. It's completely hidden in the final judgment of the court, but the court, behind just the formalism, the style, this is just direct effect, and we cannot apply retroactively, in reality is paying lots of attention to this distributive argument, which is an argument also about the cost of Europe, or when Europe is in crisis. It's been used a lot today in social policy when, we create some brackets of free movement, etc. We create some exception for free movement and other issues when it's part of there's a famous Romanian case that says, well, we create a little exception for the application of free movement because we know that Romania is in crisis. So this argument is coming today with the crisis more relevantly on the table, but it was already there when Ireland and the UK, in their briefs that you can see in the dossier de procédure, were making the argument. The very final argument, if there is time, is Van Duyn, when there is a rhetorical move. Van Duyn is the Scientology case, the whole rhetorical move that is put out there. Rhetoric, what I intend for rhetoric is really exogenous justification or a form of persuasion based on a higher common sense. And the UK, throughout that brief of Van Duyn, Mrs. Van Duyn, who tries to go and work in the UK, but she's blocked because she's the secretary of, she has to become the secretary of the UK Church of Scientology. The whole rhetoric there of the UK is very much Van Duyn, and I can read you, there's brilliant passages. Van Duyn is a cult, is indoctrinating our children. Van Duyn is worse than being a drug addict or a prostitute, so she must be as terrible as those individuals. And the whole rhetoric of the UK is really inflammatory and beautiful to read. If you do go into the brief, what happens is that the big fight in that brief is over the form or the style of public policy. How much should we allow the UK to say we don't like Scientology? It's part of our public policy exception to free movement, and therefore tell the UK depict this as an ultimate deplorable cult that nobody will want to attract. The Commission Legal Services puts out the winning argument that changes the whole rhetoric of the case. The Advocate General Marat misses the point completely in his opinion, and the Commission Legal Services does offer on a silver plate to the court the argument that what the UK are doing, they're basically discriminating. They're not going after as badly to the Scientologists existing in the UK already. They're not limiting their ability to create the church. They're trying to restrict it and police it, but they're much more harsh to Mrs. Van Duyn than to the internal one. So it's the Commission that offers this change of rhetoric and this change of focus, and focusing more on the discriminatory aspect of free movement and rather than anyone else, the lawyers of Van Duyn or anyone else in the case. So why connecting the fragments to to the matrice? I think it's really relevant, and I really do hope that also in this group you can start doing empirical work really based on theories and then bringing it down to very empiric kind of fragment and starting with, I'm not saying you're going to start counting like they do at courts on the network theories or counting all these cases with computer scientists, but I do think we need to introduce some empirics here. Thank you.